What if I told you that if a lender ignores your lawful tender, they could owe you and not the other way around? Now, in this video, I'm going to break down exactly when to take your remedy into small claims court or secure it with an administrative lien, and how to use dishonor, default, and evidence to flip the pressure back onto the debt collector. Now, I've studied commercial process, contract law, and private remedy, and I'm here to show you how to escalate the right way when your paperwork gets ignored, okay? Now, before we dive into this video, this is not legal advice. This is not financial advice. Make sure to consult with those legal representatives, legal aids, and also do your own research. This is only for educational purposes only, all right? Number two, if you're brand new, hit the subscribe button, hit the like button. When you do this, this puts me at the top of the algorithm. And the questions that people ask are going to be answered in this video, okay? Some of you guys say, oh, I watch all your videos, and, you know, may still have the same questions. And you guys know who you are. Make sure you are watching this video all the way through, because in this video, I'm going to break down things that are missed, things that people don't fully understand, nor anybody truly talks about as it pertains to the debt discharge, the consumer law, the credit repair process. All right. So once again, thank you guys once again for tapping in, man. I'm super blessed that you guys are here. It is Friday. Happy Friday to you guys. Be safe. All right. Now, you want to make sure you stay all the way to the end of this video, because I'm pretty much going to be talking about how to use that paper trail to be able to get administrative remedy. I'm going to talk about when to go to small claims court. What are some key questions that you should ask yourself prior to you escalating your claim to sue a debt collector or sue a company. We are going to talk about some of these things that you must ask yourself first before you go and do it, so that you're not maneuvering based off of hope and templates and all of that. If you can't answer these questions, don't take them to court. All right. Make sure you get to this point here. Make sure you understand the signs that means that you're ready. And we're going to talk about that throughout this entire video, about the administrative process, when to take them through private arbitration and small claims. So make sure you stay all the way to the end if you want to get that game. Now, let's dive into this video. All right. We're going to go through this relatively quickly. Make sure you guys are taking a notebook out. Make sure you guys take notes, please. Dig me? I already have my notes here, so you should do the same. I don't need to take notes. All right. And I do this on a daily basis. Okay. Number one, let's talk about when a paper trail becomes legal leverage. You dig me? Now, if you have sent a debt validation letter, if you don't know what a debt validation letter is, go watch my previous video. Okay. And this, as a matter of fact, will go hand in hand with the coupon remittance process, any bill of exchange, negotiable instrument process. If you have sent this with your negotiable instrument, then this is when you can use this as leverage. Number one, you want to send a debt validation letter. If one of your questions is, what is a debt validation letter? Just go watch all of my videos and I explain exactly what a debt validation letter is. Okay. I also have a 5-letter process where I broke down the 5 letters that you should send to a company. That's also on my channel as well. But you can Google debt validation and see the different examples online, so you know exactly what it is. Debt validation letter. Number 2, you send a conditional acceptance. You've also sent them a notice of tender. You actually notified them of your performance and your tender that you created. You gave them that conditional acceptance, meaning that, hey, I will agree to pay if X, Y, and Z. And then you also provided an affidavit of truth. Okay. And when you have sent all of these documents through and taken them through the administrative process, and you have received no proper rebuttal, the other party is now in dishonor. Okay. So the reason why you would send these letters is because it's a trap. All right. You're not going to get remedy just by sending in a coupon, just by sending in your bill of exchange and complaining. You got to take them through debt validation, conditional acceptance, notice of tender, affidavit of truth. And when you have done this and they have not responded point for point, that gives you the leverage, okay? Because under UCC and contract law says that silence equals acquiesce. So you want them to be silent. It's no use of you complaining about them ignoring you, because that means that you are at the leverage point. That means that the ball is in your court. So we shouldn't get people anymore saying, I sent this, that, and the third, and they ignored me. I don't know why they ignored me. Well, that's why. Because they agreed. That's what you should assume. Okay. Because when they are silent, when they ignore you, when they acquiesce, in better terms, you now have grounds to move from private record to enforcement. You understand me? Because if they don't have the answer, that's not the end. That's literally your green light. All right. It's the green light to start taking action. It's the green light to take the initiative. It's the green light to start challenging the company and enforcing it. All right. No more us looking at us being ignored as, man, it's over, because that's not the case. Okay. Let's talk about when to use small claims court. Small claims court is best for seeking monetary compensation, usually under 10 to 25K, depending on your state. Enforcing dishonor of tender or violation of consumer rights is best for that. And holding debt collectors accountable for Fair Credit Reporting Act and FDCPA violations. Okay? When you go to small claims court, you want to make sure you bring those certified mail receipts. You want to make sure you bring your full affidavit chain, truth, fault, and default. You want to make sure you bring your notice of dishonor. You want to make sure you bring your copy of your remittance, tender, or bill of exchange. You want to bring all the documentary evidence and anything that you have sent to them. Okay? Anything that they have sent back to you. Okay? Some of the common law claim strategies are breach of contract, failure to validate debt, attempting to collect on discharge obligations, and when that happens, your paper becomes your plaintiff and your evidence wins the case. Evidence and facts are always going to beat emotion. Okay? It's always going to be, well, they agreed to pay. Now they're moving off of emotion. Because I literally asked you for documentary evidence according to my rights. And if you are still stuck on me agreeing, or you are still stuck on things that don't matter, you are now moving with emotion. And this does not win in court. Okay? We move based off of truth. We move based off of facts. What facts can you present against my facts? And if the facts tells us that I literally attempted to perform, and not only did you refuse, not only did you ignore me, but you have dishonored, you have defaulted on multiple occasions. So that right there is a violation in itself. I hope you guys gathering that. Okay? Well, I sent in the right discharge. I got all of these. I've done everything that people told me to do. No, you didn't. Because if you did, my question always to that person is, did you take them to court? No, why didn't you? Because nothing. First of all, this is how I know you haven't done the due diligence. This is how I know you don't even understand what you sent them. Because anytime I ask a person, what did you take them through? Oh, I sent the debt, I sent this, I sent that. Maybe because they just heard these words on my YouTube channel. But then I say, okay, bet, send me those letters that you sent them. Oh, I gotta find them. See, this is how I know you're not serious. This is how I know you didn't do it. Okay, you can't fool me, all right? So when it comes to the aspect of them breaching the contract, the part of them breaching the contract is you sending a performance and them dishonoring it, okay? Because if you are attempting to perform on a contract and they dishonor it, then they are also breaching the contract as well. If they aren't giving you the proper disclosures, they are also breaching the contract as well. When you ask them to validate debt and they fail to, or they do not, or they ignore you, they are violating the Fair Debt Collection Practices Act, because they have a duty and obligation to do that. When it comes to attempting to collect on a discharge obligation, there's a thing called double recovery, double collection. That is illegal. Okay? If you know these things, then you cannot be taken advantage of as it pertains to debt collectors. Okay? Let's talk about when to use an administrative lien. Okay? Now, If you don't know what an administrative lien is, it is a claim or attachment on a property, often by a government agency, to secure unpaid debts or obligations. Unlike a lien issued by a court, administrative liens are typically issued by administrative agencies like child support enforcement agencies or tax authorities. Okay, they are a way for government entities to collect debts without going through a court process. Now, this is best for securing your claim without court. Okay, this is best for placing a private lien on an entity or agent's legal fiction. And this is best for escalating a private dispute into a commercial lien. All right. What it requires in order for you to put an administrative lien on a company. In order to file a administrative lien, you can go online to your state website or your court's website. I mean, you can type it in on Google. You'll be able to find where to file the administrative lien. But before you file an administrative lien, number one, it requires full unrebutted affidavit process. So you have to make sure that you have gone through the administrative process, through those affidavits, through the default, through the dishonor, through the notice, through the offers. If you've taken them through this process, then you can look at filing your administrative lien. Okay, it's almost like a judgment without going to the judge. Okay. And this is what they typically do to you, where they don't even show up or appear in court. Okay. You can claim of right or interest. Okay. Notice of intent to lien. You've also sent them that. And this is optional. You filed a UCC1 financing statement on said obligation. Okay. Typically, the lien attaches to property, business, registration, bonds, and public record. And the lien says, I have a claim and it's enforceable, recorded, and protected. The reason why it's enforceable, recorded, and protected is because you've taken them through the administrative process. Okay, you attempted to do a private communication with them, a private administrative process, and they still denied, ignored, still violated your rights. So when you have done this, this puts you in a position to have grounds to create your own administrative lien, put a lien on their property, business, bond, public record, and now they have to start making decisions based off of that. Either they can fight that administrative lien by showing up in court, or they can pay it. Okay. Either way, if you have the evidence that shows that you have done your due diligence and they still maneuver in a way that, is in violation, then the administrative lien is going to come in effect. Okay. Now, one of the things I want to talk about is the signs when you are ready to enforce. Okay. These are some of the questions that you must ask yourself before you attempt to do an administrative lien, before you attempt to go to small claims court. Okay. Because they're going to ask you these questions in court already. So if you just have this stuff covered, I'm not going to say you won't have anything to be worried about, but you'll be more confident if you can answer these questions. Number one, the first question you want to ask yourself is, actually, before I dive in this, hit the subscribe button, hit the like button. Okay. Let's get this video to 100 likes. Okay. Now, the first question you want to ask is, did I give them a chance to cure or rebut? What that means is, when you send a letter, let's just say they ignore you the first time. There is a letter called fault and dishonor. Okay. Opportunity to cure. When you give them an opportunity to say, look, maybe it was a misstep. Maybe it was something you missed, right? Misplaced. Here's your second opportunity to cure your fault. Some people say, well, after my first letter, I want to just take them to court. No, I mean, that is, I wouldn't say that that's very good faith-esque. You want to maneuver in good faith, so it doesn't seem like you was trying to be predatory or whatever the case may be. If you're moving in good faith, then there's nothing to really worry about. Especially if you give them multiple opportunities to cure their faults and they still don't do it, that is making them look even more like the bad guy. Okay? So after you send your initial letter, if you get them ignoring you or not responding properly, you then want to send a opportunity to cure. and say, look, hey, maybe you missed what I said. Here are my terms for my previous letter. Here are the other documents that I sent with it. Here's your opportunity to respond word for word, point for point. And if you don't, then I have no choice but to have you default. Okay? I'm literally telling you what happens if you decide not to cure, and I'm literally telling you what's going to happen if you don't rebut point for point. So after this letter, if they don't rebut point for point, then again, the ball is in your court. Okay? So did I give them a chance to cure or rebut? Yes or no question. If you're not confident in that answer, then need to tap in and understand the administrative process. Number 2, did I reserve my rights under UCC 1-308? Under UCC 1-308 is basically without prejudice, okay? When you do that, this puts you in a position of where you didn't waive your rights, because a lot of times they'll put in fine print that you waived to do X, Y, and Z. But when you put UCC 1-308, anything you was not conscious of as it pertains to the contract, you do not automatically waive it, okay? That's almost like a safeguard, okay? Another question you should ask yourself is, do I have proof of mailing, silence, and dishonor? Proof of mailing is those certified mail slips or registered slips. That silence, meaning that you can see that they have received your mail and you haven't received nothing to your mailbox. When you ask them, hey, did you guys respond? And they cannot tell you when and where they responded and how they responded, or they can't produce the letter that was the response. That is the proof of a silence. And the dishonor is when they didn't respond point for point, and that's in their response. Okay, that is when you put out there that, hey, if you do not respond, there is a dishonor, and they decide not to respond. Even if they send you a letter, because they'll do things like respond, but they don't respond to what it is that you put in the letter. Almost like they didn't read it. Almost like they're just sending an automatic letter. Okay? Such as the credit bureaus. The credit bureaus do a thing by asking you for your identification, even when you sent your identification. Okay? And this is the big one. This question right here is the big one. Can I testify to the truth of my process? See, a lot of us can send our letters. A lot of us can send the templates. But can you testify? Can you go up there and speak about the process that you went through? Can you go up there and say, hey, I sent this letter on this date, and this is how they responded. I noticed that this response didn't even respond to what I asked. Do you know exactly what you're asking them of? Or are you just sending them letters and hoping that they just comply? No. Anybody who understands the law and they have legal counsel will take a gander at your letters and say, oh, this person just sent in the template. Let's just stall them out. But when you are serious and you actually know what you're talking about, you know exactly what you're supposed to be getting back, and you know exactly what a rebuttal is and what's not. You know exactly how to respond back to a non-response or insufficient response. You know exactly what a affidavit of truth is, conditional acceptance is, what a debt validation letter requires. But if you don't know these things, then you really can't testify. You're going to be manipulated as soon as you go in there. So you got to know what you're talking about. This is why it's not about me breaking down, oh, it's this process, that process, this process. Because I can say that a million times, and if it doesn't go through your thick skull and you're not the person to go and actually understand these laws and educate yourself, because some videos I'll talk strictly about the laws. Some of the videos I'll give step-by-step guidance. But if you're not going to sit down and say, you know what, let me just actually review the materials. Let me take some notes. Let me actually go cross-reference some of these terms. Let me go online and look at the law myself and understand the law. Let me go figure this stuff out myself. You won't be able to testify to the truth of your process. Okay? I always tell people, if you cannot prove it to your closest friend, if you cannot prove it to the attorney, then yeah, you can't. You're not ready. I'm sorry. So if you answer yes to all of those questions, then you can move into enforcement by filing a small claim suit, recording a lien, and sending a final invoice or claim for damages. Only until you can answer all of these questions, yes or no, do not go to small claims court and have a unknown and don't know what you are going in there to talk about. Don't just follow a procedure and process because you think that that's how it's supposed to go and you don't even understand what you just did. I don't care how long it takes. I don't care if you sent them a letter for 90 days, you did everything right. If by that last letter you still don't understand the process and what you did, do not go to court looking stupid. Okay? I don't care how much evidence you have. If you can't testify your process and you don't even understand your process, you're going to have a hard time in there. You're going to get tripped up. Now, I'm not telling you to maneuver in fear, but be prepared. Okay? It's not as scary as you think it is, especially if you know what you're talking about. But the people that are scared to go to court do not know what they are talking about. They're hoping somebody will come in there and just speak for them. And unless you got 50 grand, unless you want to actually get remedy and lawsuit for it, you want to get the money from the lawsuit, then know what you're talking about. If you're trying to get to 5, 10, 20K, know what you're talking about. But by all means, take all these letters, write it out, send it to an attorney, and hopefully that attorney has the grace to say, you know what, I know exactly what you're doing. Boom, this is how we're going to do it. But they probably going to take all your proceeds or charge you an hourly rate. So learn this stuff for yourself. It's more power in you walking in there with the knowledge and game than you bringing an attorney, because an attorney will follow procedures too. Okay? So understand that remedy isn't just about sending letters. It's about enforcing your truth. If you don't know the truth, if you don't know your truth, if you don't know the process yourself, if you aren't truthfully overstanding the information, I'm sorry, you like I'm trying to find the analogy, but you're like look, man, you're like a fish on land. I was trying to think of the actual term, but anyway, this video is very simple, straight to the point. If you cannot ask or answer these questions to yourself and feel confident, you're probably not ready. Okay? So take the time to research, take the time to do your due diligence, take the time to take the information serious, take the time. If I'm going to go ahead and get some templates, if I'm going to go ahead and grab things like the Complete That Guide, let me reread those letters. Let me read those letters to its fullest and try to understand them. Not just fill in the blank and send it off. Oh, I sent them this letter, that letter, this letter. Okay, what was you telling them to do? Did they give you what you asked for? Yeah, they sent me a copy of the loan agreement. Well, what else did you ask them for? Because or they ignored me. Man, when people tell me that they've been ignored, it's almost like you haven't watched any of my YouTube videos. You may claim you watched it, but you didn't. You didn't listen, okay? It's very simple to get ahead in life. Just read the information, okay? I can't apologize for being blunt, because they're not going to give you any cut cards when it comes to the court system. When it comes to the judges, they're not. They're going to be very blunt with you. So understand this. If they don't respond to your remedy, it's your move, okay? It's time for you to make your move. The court is one way, but the private lien is another. But either way, silence is no longer your enemy. It's actually your evidence. Use their silence against them. Use your evidence and proof and actual truth against them. Use the facts against them versus their emotion. You flip the script and make them emotional. All right. Thank you guys for watching this video. Make sure down below you tap into the Complete That Guide if you want to learn more about this. You want to be able to join the Complete That Guide community, becoming an affiliate, but also at the same time get those letter templates so that you can be educated. Okay. If you have a hard time searching this stuff up and looking up letters, because I'll tell you, you can go online and look these letters up. They probably won't look like mine, but you can go online and look these letters up. But if you want to get the letters that I put together and use them as an educational tool so that you can be able to learn how to write your own letters, tap into the Complete That Guide. Number 2, if you want to work with me one-on-one as it pertains to credit, getting funding, taking your credit score to a 700 plus so that you can be able to be in position to help yourself, help your family, and change your life financially, tap in with that one-on-one mentorship. Okay, anybody else is part of my one-on-one mentorship, I inherently help them understand the processes that I talk about already. It doesn't mean I'm going to sit there and be your attorney and write your letters for you. Okay, but I will teach you and educate you and mentor you on exactly on how I got to the point that I'm at right now. Okay, and I didn't just do it by asking somebody what to do next. I actually took the time to research. I listened took notes, and I did my own research. And it requires a person's accountability to be able to say, all right, bet I can learn from this person, but I'm gonna also take what I learned and add to my learning. Those are the people I'm looking for in my one-on-one mentorship. Number 3, if you want to follow me on Instagram, it's at biz.nick. Also tap into my Twitch. My Twitch link will be down below. If you need to get your credit report, you can get your credit report for $1 for 7 days through Smart Credit. The link will be down in the description. My last question is, have you ever wondered when it's time to go from process to power? Drop a comment down below. Remember to like, subscribe, hit the bell for the post notifications, and make sure to comment the word discharge if you got all the way to the end. I love you guys, and I'll see you next time.